Uy. Okay, so we are down to the last topic on human rights, and these are human rights in the Philippine criminal justice system. So basically, it is just a repertoire of the Bill of Rights and the rights of the accused under the criminal procedure. Most of you have already read this. As a matter of fact, you have already opened some of its contents through ProfCon because we have dealt with several human rights also, especially the Bill of Rights in under ProfCon. So plus we've already discussed the unwarranted searches and seizures and unwarranted warrantless arrest or arrests. So this will be just a continuation of the other available human rights that are found in the Philippine criminal justice system. So the first one would be the rights of the accused during trial. So Section 1 under uh, criminal procedure, it states here that in all criminal prosecutions, the accused shall be entitled to the following rights. They have the right to be presumed innocent until proven guilty, to be informed of the nature and cause of accusation against them, to be present and defend in person and by counsel at every stage, meaning the right to counsel at all stages of the proceedings, to testify as witness in his own behalf, to be exempt from being compelled to be a witness against himself, the right against self-incrimination, to confront and cross-examine the witnesses against him, to have compulsory processes issued to secure the attendance of his witnesses, to have speedy, impartial, and public trial, and to appeal in all cases allowed in the manner prescribed by law. So the basis of the rights of the accused is enshrined under Article 3, Section 14. Again, it is a mere reiteration of the right under this act, which states that in all criminal prosecutions, the accused shall be presumed innocent, the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory processes to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial will proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. So, what is the right to be presumed innocent until the contrary is proved beyond reasonable doubt? So, this means that you are presumed innocent until all processes have been exhausted in order for you to determine whether or not you are guilty or not. So based on Article 3, Section 2, again, another basis for this right is that in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proven. So how do you counter the presumption of innocence? It can only be countered with a quantum of evidence required in criminal cases, which is proof beyond reasonable doubt. Now, please take note of this, proof beyond reasonable doubt. This is the quantum of evidence required in order for a person to be convicted of a crime. So what do you mean by proof beyond reasonable doubt? That doubt engendered by an investigation of the whole proof and an inability after such investigation to let the mind rest each upon the certainty of guilt. Meaning, sa pasabot aning proof beyond reasonable doubt, sure gyud ka, wa gyud pagduha-duha na siya ang nihimo sa krimen. And once nakaingon kag siya gyud, imong huna-huna kay at peace ba na nakaingon gyud ka na wa ka nagduha-duha na siya gyud ang nagbuhat sa krimen na i-charge sa iya. So that is proof beyond reasonable doubt. Without a doubt, you are sure. Why pagduha-duha? You are sure na siya ang nag-commit sa crime. Now, in the prosecution of cases, in order to have a successful conviction, the burden lies on the prosecution, meaning it is our job as prosecutors to convict the accused to the crime charge. So the prosecution must rest on the strength of its own evidence and must not rely on the weakness of the defense. So for example, weak ang ebidensya sa prosecution. Tapos, ang gihimo sa prosecutor is nibangka siya dito sa weakness food sa evidence sa defense. So dito siya nag-rely sa defense sa weakness sa defense. So sa may tabuan ni, again, you have to remember that it is always the job of the prosecution to secure a proper conviction because it is within the prosecution the burden to prove whether or not our evidence is strong enough to secure a conviction against the accused. So we must always rely on our strength, on our pieces of evidence, and not on the weakness of the opposing counsel's evidence. Now you have here an equipoise rule. What does this mean? Where the evidence in the criminal case is evenly balanced, the constitutional presumption of innocence tilts the scales in favor of the accused. People versus Eliza. So I have used this in several of my resolutions. So gitanong ako, okay, balanse ang ebidensya sa complainant, balanse po ang ebidensya sa depensa. So what will I do? Usually, ang ginabuhat na ako, nag-equipose rule ko. So I put there in my resolution that since the evidence of all parties are evenly balanced, hence we must follow the constitutional presumption of innocence. Thus, the accused should be the case against him should be dismissed. O na ginabuhat. Kaya mupabor man sa akusado kung evenly balanced ang ebidensya. Alright. Next is the right to be informed of the nature and cause of accusation against him. So it is vital for the complaint or information to contain matters required by the statute or rules. So may pasabot ani. When you file a complaint, you should allege there the nature and cause of the acts this certain accused performed. Kaya para ma-apprise siya or ma-notify siya kung unsa iyang gibuhat, unsa iyang kamali, unsa iyang krimen na iyang nahitabo. Now, when you file a complaint, it will be our job to secure whether or not your complaint is complete or verified or has a cause of action against the accused. So once we've already resolved this, we file an information before the court and we file the case before the proper courts. Now, kaning information, diya nakabutang kung giunsa nimo pag-perform ang crime. Nganong kinahanglan nato ibutang ning information? Because this will be the set of words that will apprise the accused of what the nature and cause of accusation against him. So an example of your information is, it should be in writing, charging a person with an offense, subscribed by the prosecutor and filed with court. I'll give you an example of information. Now, this is an information against certain individual named Rowan Joy A. Aguidaog because he violated Section 11 in relation to Section 25 of Republic Act 9165. So Republic Act 9165 is the Comprehensive Dangerous Drugs Act. He violated Section 11 thereof, which is he possessed marijuana ba ni? Oh yeah, marijuana. So he had in his possession marijuana plus nag-positive ba yun siya sa iyang ihi. So muna in relation to Section 25, nag-positive og marijuana sa iyang ihi. So we have to inform him of the nature and cause of accusation against him para makaprepare siya sa iyang depensa. This is a constitutional right because the accused has to be notified of his nature and cause of accusation against him. Plus, this will form part of your due process. Kung saan mo prepare sa akusado if wala siya kabalo kung unsa yung gibuhat na krimen. So, a very vital ang information. So, diyan nakabuka ko siya kung unsa ang iyahang mga gipang buhat na krimen. So, during arraignment or reading of the information before the accused, the court interpreter will inform the accused of the nature of the charges against him. So the court interpreter will say, people of the Philippines, laban kang Ruwen Joy Aguidaog sa pagbayular sa Section 11 in relation to Section 25 sa Republic Act 9165 o Comprehensive Drugs Act of the Philippines. Ang nakapirmado na piskalya, gaakusakan mo, Ruwen Joy Aguidaog, sa pag-possess. Sabi, possess in Bisaya, I forgot. Under Section 11, Paragraph 2, sa Paragraph 3 of Article 2, Republic Act 9165 in relation to Section 25 thereof, committed as follows. Sa niadtong Setyembre 8, 2021, sa tuig na 2021 sa Baganga Davao Oriental, Philippines o sa ilalom aning halangdong husgado, ikaw na akusado Ruwen Joy Aguidaog na walay permiso sa balaod o ikaw na possess o naay one tape sealed transparent plastic sachet weighing 3.75 grams marked as RRPE 1 and isa pa ka blue plastic bag na nagkantidad og 28.754 grams marked as KPJ2 na tanan ni nagpositibo sa presensya sa marijuana, isa ka dangerous drug. Ug in the course of said possession, ikaw na akusado, ang imong ihi nagpositibo sa THC metabolite, which is herein alleged as an aggravating circumstances. Supak sa Balaod, Baganga, Davao Oriental, Philippines. So, that's how you read the information before the accused kay para masabtan gyud niya kung unsa tong iyang gihimo or gi-violate na balaod or iyang krimen na iyang gihimo. Nain pangutana? Is this your first time to see an actual information? Hello, questions?
Wala, sir.
Wala. Is this
Wala
your
po.
first time to see an information?
Yes po.
No, sir. Nakakita na
Ano?
ko ana lang.
Nakita na kaani. Kung sabi mong
Yes,
krimen
po.
na imong gibuhat.
Ay dili sir katong sa sa manual na mo ba sa CDI last year. Naman siya sample.
Okay, sige. So next is your right to be present, defend in person and by counsel at every stage of the proceedings from arraignment to promulgation of judgment. So basically, this is just your right to counsel. Why? Why do you need a counsel? Of course, you need the presence of a member of the bar in order to assist you in all stages of the proceedings because as a normal being, you do not know what are the technicalities of these proceedings, especially if you are not learned of the legalities of the proceedings. So if you are denied with the right to counsel, then there will also be a grave denial of due process because you are not duly assisted by a member of the bar. So this right also covers individuals under custody of the law, that is by virtue of Republic Act 7438. So any person arrested, detained, or under custodial investigation shall at all times be assisted by counsel. So How do you apply this in your work? Should you arrest a person, detain a person, or put a person under custodial investigation, you, as a police officer, should respect his right to be assisted by counsel at all times. Custodial investigation, say meaning ani. This is the stage where the police investigation is no longer a general inquiry into an unsolved crime but has begun to focus on a particular suspect taken into custody by the police, who carry out a process of investigation that lends itself to elicit incriminating statements. Pasabot, gipatawag na mo sa police because ang mga lining sa pangutana kay dili na asa man ka atong niadtong anin adlaw, but ang pangutana is ikaw ba tong nipatay kang certain AAA, kung ikaw ba tong ni-rape kay certain BBB. Ingana na mga pangutana ba very specific na whether or not ikaw ba yun ang nag-commit sa crime. Once ingana na gani ang lining sa pangutana, then the right to counsel already attaches because you are already under custodial investigation. Now, the purpose of being assisted by counsel at all times is to prevent the uncivilized practice of extracting a confession. So any extrajudicial confession made by a person arrested, detained, or under custodial investigation should be in writing, signed by such person in the presence of his counsel, or kung wala ang imuhang abogado, it should be upon a valid waiver and in the presence of his relatives, such as parents, elder brothers, sisters, spouse, or pertinent members in the community, the mayor, the judge, the district school supervisor, priest, or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. That is by virtue of Republic Act 7438. In short, if an individual confesses to the crime, that confession will only be admissible in court if it is in writing and signed by such accused in the presence of his counsel. Meaning, at the time naghimo siya confession, gisuwat niya og na ang iyang abogado. Kung wala ang iyang abogado, then waiver ang mahitabo ana. So dapat naagyapoy kasulatan ng iyang gi-confess ang iyang gibuhat na krimen ug na ang iyahang mga relatives sama sa iyahang ginikanan, brothers and sisters, iyang asawa, or kung wala ang iyang relatives, ang pertinent or ang mga substantial members sa community sama sa tuang municipal mayor, ato ang municipal judge o ato ang district school supervisor, napod ang ato ang pari o minister of gospel, depende sa kung unsay gusto sa akusado. If wala ni siya nakasulat and if wala ni siya na-assist o abogado or any relatives or any members of the community, that confession will be inadmissible as evidence, meaning you cannot prove that in court. You cannot bring that in court as evidence. Again, to reiterate, Republic Act 7438 is an act defining certain rights of a person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers, and providing penalties for violations thereof. If I remember it correctly, if you fail to do your part as a police officer, you will be penalized under this act, either by imprisonment, by fine, or both. Now, the next right of the accused is to have speedy, impartial, and public trial. So, what do you mean by a speedy, impartial, and public trial? This one is one free from vexatious, capricious, and oppressive delays. Its purpose being to assure that an innocent person may be free from the anxiety and expense of a court litigation, or having determined the shortest possible time compatible with the presentation and consideration of whatsoever legitimate defense he may interpose. Meaning, For you to have a speedy and impartial public trial, dapat walay mga delay na nanghitabo. Gusto mo ni mga delay? Kanang mga delay na, for example, wala nagpakita ang complainant for no justifiable reasons. Nga naman, these are vexatious, meaning ginainis lang ni mo ang unsa ba, ang akusado. So, if you do that, the accused will have to invoke his right to have a speedy and impartial public trial. If you don't appear, if ikaw ang complainant, dili ka mo appear sa court litigation for a period of three straight proceedings, then the right already attaches, and he will have to invoke the right to speedy trial and have this case dismissed. Naipangutana? Wala. Okay. We exempt from being compelled to be a witness against himself. So this is the privilege against self-incrimination. So no person should be compelled to be a witness against himself, meaning nobody can force you to admit your own wrongdoings. Nobody can enforce you to admit your guilt. So this is the right against self-incrimination. So there are certain cases wherein makaingon ta na dili man ni unsa kani siya na ginabuhat nato is it is not self-incriminating on the part of the accused. So, unsa man ni sila. For example, isa may mga lalaki diri. May mga boys diri. Mga Mr. Dugos, for example. Si Mr. Dugos, for example, rape Miss Pelicano. Kanya, wala kabalo ni si Mr. Dugos na naadi siya'y gonorrhea. So, si Miss Pelicano, let's say, kung saan siya, unsound mind, and let's say minor, and let's say autistic. So wala siya kabulok kisay ni rape sa iya, but we all know that it was Mr. Dugos. Turns out, after the rape, Miss Pelicano suffered from gonorrhea. So in order for them to check kung kinsa ang nag-rape sa iya, gipa-test ang mga lalaki within the area kung kinsa tong naay gonorrhea. So niabot ang panahon na it was already Mr. Dugos who was about to be tested for gonorrhea. So kuhaan siya blood sample. So makaingon ba si Mr. Dugos, I will invoke my right against self-incrimination because the withdrawal of my blood will tend to put me as the accused in this case of rape against Icano or Lynn. Now, is the contention of Mr. Dugos correct? Is the withdrawal of blood incriminating on the part of Mr. Dugos? Kasi gusto mo answer. Wala mong sumutubag.
Sir, siya ng kanang gonorrhea, sir?
Tulo. Can he invoke the right against self-incrimination? Katong pag-ingon sa iya na, the court will order, kuha na siya dugo, tama na to, kung na siya gonorrhea, kung na siya gonorrhea, siya yun ang akusado diri sa ato ang kaso. Can he invoke the right against self-incrimination? What do you think? Mr. Sumambot? So, wala? Huwag mo tubag? Sa bagay ito, kasi ito nag-tapos akong exam. Mr. Recom, No, Mr. Cabrera.
Sir,
What do you think?
para sa ako, sir, yes, sir.
So you think the withdrawal of the blood will incriminate him for the crime. Hence, he should invoke the right against self-incrimination. Tama ba? Kanay mong tubag?
Yes, sir. Na siya right na mag-invoke, sir.
Okay, sige. Unfortunately, your answer is wrong because to be exempt from being compelled to be a witness against himself only covers testimonies, meaning testimonia, words, meaning you cannot say anything against yourself. But this one, the extraction of blood, does not involve in extracting words from you. As a matter of fact, mechanical lang ang pagkuha og dugo sa imuha. It does not need the use of your intelligence nor your wit in order for you to answer the question. Hence, the removal of blood from you is not incriminating. Kasi mechanical mechanical work lang siya and not testimonial in nature. Nakuha ninyo ingana ang answer? Ano dili siya incriminating?
Yes, sir.
All right, very good. So, for example, ikaw Mr. Cabrera, may babae pa dali. Let's say you rape Miss Castaños. And Miss Castaños did not know who raped her. But she knows that the individuals there on that night that it happened was you, Mr. Bercero, and Mr. Olarte. So, ang gibuhat niya, nagpa-paternity test siya sa inyuhang tulo, Mr. Cabrera, Bercero, and Mr. si Louis J. Olarte. Now, can the three of you invoke the right against self-incrimination?
Wala, sir. Kay,
Yes. Okay, thank you. At least nag-stick ang rationale before. Yes, the correct answer there is no, you cannot invoke the right against self-incrimination because what is just being asked here is mechanical in nature, meaning the withdrawal of blood from your body. And there is no extraction of words or wit coming from your mouth. Hence, when something is being withdrawn from you, let's say blood, semen, to check the paternity, then that is not self-incriminating. Including the size of your foot. For example, nangawat mo dito sa SM, kunya, timing, nakatamak mo og paint, kunya, kaning natamak kayo na paint, nag-form og footprints sa inyo ha, ingana ka na ko inyong footprints. So, ano sila, hala, i-test daw nato kung sa itong mga individuals diri na ingani ang footprint o ang size sa iyang foot. So, ipatest mo individually. Kunya, timing, kay kaning si Mr. Sumambot, nag-fit ang size sa iyang foot dito sa printed na foot. So, Mr. Sumambot cannot invoke the right against self-incrimination because there was no extraction of testimony coming from him. It was just that he was just asked to put his foot on the printed foot on the ground. So may lying, if mechanically, kani sila ng mga tests na ni, you cannot invoke the right against self-incrimination. So sa naman itong mga pwede ka maka-invoke of right against self-incrimination. Mo rin mga
sir,
examples.
Sir,
Sa?
sir, pwede mga tana.
Sure.
Katong example, sir, katong kay Duterte o kay Trillanes, sir, katong tato gani sa likod.
Oo.
Wala lagi niya ang sa to siya murag mechanical ba guro to kay syempre kuan kanang di ba giing na ni Trillanes na ipakita tong tato niya sa
Dragon tattoo. Oo. So, if ever ingana man, Duterte cannot invoke the right against self-incrimination because wala may gi-extract sa inyahan na testimony. Wala mo siya niingon na wala mo siya giingon against himself. But kung usa lang mo itong naa sa likod is just mechanical in nature, meaning wala. It's just an art behind his back, something ingana good. So you cannot, if he were the person to be in question, then he cannot invoke the right against self-incrimination. Natubag ba na ako, Mr. Cabrera, imong pangutana?
Okay. Oh, sir. Yes, sir.
But again, you cannot file a case against the president because the president is immune from suits. This is this is just a segue sa inyong lesson. When a president sits within the first 6 years, the president is immune from all kinds of suits, meaning you cannot file a criminal case against him, you cannot file a civil case against him, you cannot file an administrative case against him, except only if there is loss of public trust. Mao lang man na ang impeachment proceedings lang man ang pwede nimo i-file against the president. But other than that, he is immune from suits. Okay? So, unsa naman itong mga things or unsa naman itong mga pwede ka maka-invoke o right against self-incrimination apart from your testimony. This is one of the examples, kind of forced reenactment. For example, pulis ka, kunya, nadakpan mo ang isa ka akusado, let's say si letter A, na nidagan kay nakapatay siya o another individual. So you ask him, oo, sige daw, i-reenact daw kung inso nimo to pagpatay sa imong amigo. Now, this is already covered against self-incrimination because reenacting is like a form of communication. You are extracting communication from another individual. So when you reenact, you use your mind and you use your wits. So pag reenact ka, kung gusto rin magpatay, wala, GG gid ka. Kanang, that's the time that you should invoke your right against self-incrimination. So if, for example, hitabo ni sa inyo ha, o sige daw, yun sa man niyo pag-abri yun sa inyo paglungkab sa storage room ni Mr. C. So inyong i-demonstrate, ayun yung i-demonstrate. Dapat ingnan ninyo ang police officer, sir, I would like to invoke my right against self-incrimination. So, kana. What else? Handwritings. So for example, you send death warnings or death letters against a certain individual, patyonti ka someday, patyonti ka ugma, patyonti ka inganing orasa. Yeah. Nakita ni muhang letters. Kunya, isa ka sa mga suspect. Sige daw, you use your pagsulat daw, kung tawag na to, kung match ba yung handwriting sa notes. So that already, if you're being asked in that manner, then you should invoke the right against self-incrimination because when you do your handwriting, you are extracting information or communication from that individual. So that is already not mechanical in nature. Nakuha ninyo?
Yes, sir.
Okay.
Yes, sir.
Ana ha? Hi, sorry if you had trouble with the services earlier. It's sick ang globe ka. Okay, pulos. Anyway, so these are your principles in self-incrimination. Remember, Hannah, ang self-incrimination will only apply to testimonies and not to mechanical workings. All right. So since we're talking about immunities, there are different types of immunities. You have here your transactional immunity and the use and derivative use immunity. Transactional immunity means the blanket or total immunity, meaning the witness, once he provides a testimony for the court, that testimony could not be used against him and could not be used for future crimes against him. In short, totally immune yun siya from the present case and for other future coming cases. Whereas, ang imuhang use and derivative use immunity, it will only prevent the prosecution from using the testimony of the witness at that instance. However, that testimony will no longer bar him from future prosecution of crimes. So for example, ihatagan si Mr. Ihatagan si Miss Palakit og use and derivative use immunity for the crime of murder sa iyahang let's say murder. So she can only be immune from the crime of murder kaysa paggamit sa iyang testimony. But should she have other crimes to be prosecuted against her, then she can no longer use her use and derivative use immunity against all other crimes. In short, one time, may time lang siya magamit. And for a specific case only. Any questions so far? Wala? Sige. Confront and cross-examine the witnesses against him. Ngano? Why is it the right of an accused to confront the witnesses who is going to testify against him? This is to test the accuracy, falsehood, and uncover the truth of those witnesses that testified against him. Remember that in trying to defend yourself, you have to prove that the witness who testified against you should be destroyed by destroying the credibility of his testimony. So mo nang important sa cross-examination and to confront the witnesses. Kaya diyan mo matest kung kung galaong bagay diyan ang tinuod or dili. Kung aon ba ipigatago naan, aon ba mga protektahan naan. So that is the reason why you should have the right to cross-examine the witnesses against you. To have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. So, it is the right of the accused to force witnesses to appear before him. For example, si Mr. Olarte was charged of the crime of serious physical injuries. But gibuhat na niya ni na crime because out of self-defense. And the only individual who saw him defend himself was Mr. Bersero. But si Mr. Bersero is a tamad individual who's not willing to help his fellow countrymen. Wa siya nagtabang kay Mr. Olarte. So say remedy ni Mr. Olarte. Mr. Olarte may ask from the court to compel Mr. Bersero to appear in court by virtue of a warrant. So that's how powerful our processes are. To appeal in all cases allowed in the manner prescribed below. You have to remember though that appeal is only available to the accused because it is only the accused who has the right to appeal. Kaya kung ikaw, complainant mo, apilar ka, sinapildi ka, mo apilar pa ka, then ma-double jeopardy na ang ang akusado. So never ending na iyang kaso, ana naman niya eh. So that's why we give preference, we give a lot of rights to the accused. Kasi sila man ang tehado. The right bail or the right fianza. Section 1 of Rule 115 states the definition of bail or fianza. It is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. Now, bail, again, diba, is a security for you to appear in court. Why? If you were detained or if you were arrested, for you to enjoy your temporary liberty, you have to post cash or you have to post a bond. Meaning, mag-deposit ka o kwarta sa court, promising that you will appear whenever the court will summon you. Now, what happens if you don't appear in court? Then, katong cash ba na imong gi-deposit will be forfeited. Meaning, mawater, imuhang piyansa, maanto dito sa judicial fund. Karang, once maanto sa judicial fund, may mo na ng bonus sa mga employees, sa mga Supreme Court employees. So that's why be careful. Once you're out on bail, you should appear before the court because, again, it is the guarantee for you to appear before the court whenever required. Again, purpose. Appearance of a person before any court when so required, and accused should appear before the proper court whenever required by the court. So, on sa basis ay mukhang bail. Why should we provide bail to an accused individual? Because the accused has the right to temporary liberty. Isa pa, because the accused is presumed innocent until proven guilty. And lastly, it is the right of the state to protect the people and the peace of the community from dangerous elements. Mona, the more heinous crime na imong commit, the higher the bail. So this is one way of protecting the community from you. So kung example, imong commit lang is unjust vexation, meaning wala lang, iniinis ko lang yung kapitbahay ko. So that crime has no bail actually. So the lesser your offense, the smaller or as much as say gani wala bail. So ingana ang ato ang process dire. Constitutional basis for bail is that all persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall before conviction be available by sufficient sureties or released on recognizance as provided by law. So mo na imong constitutional basis nganong naatay piyansa. Of course, there are different types of bail, meaning dili lang cash ang pwede nato ihatag sa korte kung gusto tayong maka-enjoy sa atong temporary freedom. For example, wala kay kwarta, you may always use your property, imong titulo, to secure your temporary liberty. You just have to make sure that this property is imuha gina siya, akusado gina siya, and makover niya kung how much tong bail. For example, ang bail is let's say 100,000 pesos. Imong property dapat po magkantidad og at least lang man 100,000 pesos para ma-consider siya as piyansa. Isa pa, corporate surety. Wala kayo ni siya diri sa tuang area because bukid man ning atuang lugar. Ang corporate surety is much common in highly urban areas wherein corporations, they have this game business wherein they will provide cash para sa mga in order for you to petition for bail. Then you have the most common form of bail, which is cash deposit. Cash, kwarta imong i-deposit mismo. And lastly, recognizance. When you say recognizance, upon promise, promise yun na, or naakay certain na imo bangka sa imuha na kani siya mo appear yun before the court, that is recognizance. But again, Di ba, sa'yo na kayo recognizance, igo na ka mo promise, igo na mo bangka para sa mga. Again, ang recognizance hindi siya basta-basta. Recognizance will only apply to light penalties, meaning crimes which have lesser penalties, diyan lang natin mo siya ma-apply ang recognizance. So in short, if you committed the crime of murder, which is a heinous crime, di ka pwede mag-recognizance. Kay, alam nga naman, upon promise lang ka, di lagi ko mo takas, promise lang ko na mo appealing ko before the court. Ayun, aplika mo lang siya to lesser crimes, light felonies. Naipangutana? Any questions so far?
No, sir.
Wala. Medyo tangan na pala ko hearing sa December 14. Grabe naman din sila yun. Uy, pahumay. Ay, kaya. Yes. Ay, may pahinga. Okay, sige. Hearing tayo. Anyway, moving on. Napatay last na siya. The right against double jeopardy. So, it is the right of the accused against double jeopardy. It adheres to the constitutional prescription against double jeopardy and provides the requisites in order for double jeopardy to attach. So, kung sa yung double jeopardy, kung ang isa ka akusado, na-convict na siya or na-acquit na siya sa isa ka kaso, ug na-dismiss na po by a court of sa isa ka korte, then dili na din siya pwede ma-revive. For example, in a given set of facts on, let's say, December 9, 2021, imong gisagpa si letter A. So, if eventually na-acquit ka or dismiss ni or terminate ni sa court, that case could not be refiled against you because yun nga, ano ka na, dismiss ka na, or na. The reason ani is because kung sige kag padayon og refile, then wala na ikaw humanan imong kaso. So ang malugi ana is ang akusado. So mao na natay right against double jeopardy. Nakuha ninyo?
Yes, sir.
Questions? Okay, sige. Okay, for example, I have a friend who was previously charged of altering boundary. Kaning altering a boundary kanang mohon gani, kanang inyong gikuha o gipatakaan yung butang maski asa, di ba? Uso man na din sa tuwang bukid. Kanang labi na pag nakay, lamoy away sa area ninyo. Walang altering of boundary, kanang mohon inyong gihilabtan. So, ingon niya, he pleaded not guilty, so nag-trial na. Eventually, na-acquit ning naggulit sa mohon, nag-alter sa mohon. Kay ingon sa court, the evidence against him was not strong enough to convict him. So, another similar case was filed against him based on the same set of facts. So, what will he do because of that situation? Then, ang legal advice na mo is to quash the information against him on the ground of double jeopardy. Ano? Kay same set of facts man ang imong gi-refile against sa iya, dili bag-o, and plus na acquit na siya by a competent court, then that means ni-end na gyud ang iyahang liability, wala na. So, he can always invoke the right against double jeopardy. Mao na siya ang classic example. Okay. Right to due process. What is the right to due process? It is a guarantee against arbitrariness on the part of the government, whether committed by the legislative, the executive, or judiciary. It is a law that hears before it condemns. which proceeds upon inquiry and renders judgment only after trial. Meaning, the right to due process is a process wherein hatagan kang tsansa sa korte na maminaw sa imuhang side before siya mag-render og judgment, whether i-convict ka, i-acquit ka, or i-dismiss ang imuhang kaso. So it is the right that hears, paminahon ka before ka i-condemn. Now, the right to due process protects three different kinds of human rights, which is the right to life, liberty, and property. One, very common siya. Very common yun ang slogan na no person shall be deprived of right to life, liberty, or property without due process of law. Meaning, dili ka pwede mawadan o katungod sa imong kinabuhi, sa imong freedom, o sa imong propriedad, kung wa ka niagi og due process. Kinahanglan gyud ka mo daagi sa due process before kuhawon imong kinabuhi, imong freedom, o imong propriedad. So the essence of due process is the opportunity to be heard or explain one side. So, I guess that ends all of the rights under the criminal justice system because we already discussed the right against illegal searches and seizure and the right against unlawful arrest. So that ends your human rights topic. Hopefully, you learned something out of it and perhaps you may be able to apply it to your community and perhaps apply it to yourselves. Pero let's hope na di po moabot sa punto na ingana, no? Kay laban, di ba kayo ning makalaban nimo ang gobyerno o ang agents of the state? Anyway, any questions so far?
No, sir.
Wala na?
Wala po.
No, sir.
Sige, so again, our exam will probably fall between 16 to 22. Just wait for further announcements so that you may be able to enjoy fully your Christmas break. Okay, as far as I know, the calendar of activities will end on the 23rd or 24th. Not sure though.